The Supreme Court just made a move that shocked gun owners across America. The AR-15 case was denied. No ruling. No explanation. Just silence. And a lot of people immediately jumped to the wrong conclusion that gun owners just lost. But here on Gun Law Decoder, we don't deal in headlines. We decode what the law is actually doing, because while the Supreme Court refused to hear the AR-15 case, it quietly signaled interest in other gun cases that could impact magazine bans, carry permits, registration laws, and even who is legally allowed to own a firearm. So today, on Gun Law Decoder, we're doing a full 2026 gun rights status check. Where do our 15 bans really stand? Are magazine limits the next domino to fall? What's happening with carry permits? And could millions of Americans see their gun rights restored? Let's break it all down clearly, accurately, and without political noise. Chapter 1. Why? The AR-15 case was denied. Let's start with the case everyone is talking about. Snope v. Brown. The challenge to California's AR-15 ban. The Supreme Court declined to hear it. And here's the first thing Gun Law Decoder viewers need to understand. A denial is not a decision. The Supreme Court denies thousands of cases every year. It does not mean the justices agree with the lower court. In fact, there are several strategic reasons the court may have passed on this case for now. They may want a stronger factual record, they may want more disagreement between lower courts, or they may want to address magazines or permits first. Supreme Court plays the long game. And if you've been following Gun Law Decoder, you already know the court rarely jumps into the biggest cultural battle without setting the board first. So while our 15 bans remain in place today, this issue is far from over. Chapter 2. Why the fight may have shifted. Instead of AR-15s, the court's attention appears to be shifting toward magazine bans, specifically Ocean State Tactical v. Rhode Island. This case challenges Rhode Island's 10-round magazine limit, and from a Second Amendment standpoint, this is huge. Why? Because magazines holding more than 10 rounds are commonly owned, widely sold standard equipment for lawful firearms under the Supreme Court's Brune standard. That matters. Brune made it clear, if something is in common use for lawful purposes, it is protected unless the government can prove a deep historical tradition of banning it. Here's the key detail Gun Law Decoder wants you to notice. The Supreme Court requested a full response from Rhode Island instead of denying the case. That's not routine. That's a signal. It means at least one justice is seriously considering taking this case. Chapter 3. WHAT. If magazine bans fall. If the Supreme Court strikes down magazine bans, the consequences would be massive. States like California, New York, New Jersey, Hawaii, and others would be forced to rewrite their gun laws. Lower courts would no longer be able to ignore Brune. And here's the strategic insight Gun Law Decoder viewers should understand. If standard capacity magazines are constitutionally protected, then banning rifles designed to use them becomes much harder to justify. In other words, a magazine ruling could weaken AR-15 bans nationwide without even mentioning AR-15s. This may be exactly why the Supreme Court is moving carefully. Chapter 4. Hawaii's permit system under fire. Next up, Wolford v. Lopez. Out of Hawaii. Before Brune, Hawaii had one of the most restrictive permit systems in the country. Officials had broad discretion to deny permits even to law-abiding citizens. Brune ended that. But Hawaii didn't fully comply. Instead, it kept layers of permits, registration, and government control. Wolford v. Lopez asks a simple question. Can states keep enforcing discretionary gun laws after Brune said no? If the Supreme Court steps in, it could force Hawaii to dismantle its system, send a warning to other resistant states, strengthen carry rights nationwide, and, as Gun Law Decoder has warned before, states that ignore Supreme Court precedent eventually get corrected. Chapter 5. The most underreported casino. Let's talk about the quietest, but possibly biggest case. United States v. Hemanith. This case challenges the federal law that permanently bans all felons from owning firearms even for non-violent crimes. Hamani committed a non-violent tax offense decades ago. No weapon. No violence. Yet his gun rights were stripped for life. Under Brune, the government must prove this kind of ban has historical roots. And here's the problem. There is little historical support for blanket lifetime bans on non-violent offenders. Lower courts are already split. If the Supreme Court takes this case, it could restore rights to millions and automatic lifetime bans redefine who the Second Amendment protects. This would be one of the most consequential rulings in modern gun law. Chapter 6. Gun Right Status Check 2026. So here's where things stand. Decoded by Gun Law Decoder. AR-15 bans? Still standing, but legally. Vulnerable magazine bans. Strong chance of Supreme Court review. Carry permits. States resisting Brune are under pressure. Felon bans. Lifetime prohibitions may not serve. The Supreme Court isn't backing away from the Second Amendment, it's reshaping it. And every signal points toward stronger constitutional protection. Conclusion: the fight over gun rights is not over. It's entering its most decisive phase yet. Every case we covered today could reshape gun law across all 50 states. If you own a firearm, if you care about constitutional freedom, subscribe to Gun Law Decoder and turn on notifications. We break down every Supreme Court move clearly without fear-mongering or political spin. Comment below. Should the Supreme Court strike magazine bans before AR-15 bans? Share this video because most Americans still don't understand what's really happening. This is Gun Law Decoder.